Hello everyone. I'm Michael Ettinger, and I'm here doing our second webinar during the pandemic. I hope you can all hear me better. I'm using a microphone this time. I'm sorry about that last week, but thank you for those who pointed it out that I do need a microphone, and I hope it's much better for you. Today we're going to be talking about estate planning for people who have dependent children, either special needs or dependent for other reasons. Either they can't handle the money, or they don't have the life experience, or they haven't had the wherewithal. Just generally, it runs a whole gamut of people who have children who can't handle financial matters. A lot of them haven't had the same success in life as their parents. So before we get into the topic, I want to offer anybody who has a question to email me at mettinger@trustlaw.com. So if you have a question that wasn't answered today, email me. I'll answer it by email. Again, mettinger, METTINGER, @trustlaw.com. I want to take a moment to thank Allison Thompson, our Chief Technology Officer, for setting up this Zoom side chat and providing me with a microphone and other tools to do the job. I should mention that Ettinger Law Firm plans to reopen the first week in June. Of course, depending on circumstances, but that's our plan now. We are doing estate planning remotely. We have executed trusts, wills, powers of attorney. The law allows us to do that. We have special legislation from the state bar allowing us to witness documents remotely, so we can watch you sign on Zoom. We can notarize remotely. We can actually do pretty much whatever we were doing before, but in a different way. I know some of you will have questions. I won't be able to answer them during the recording, but I will certainly answer them by email afterwards. When we do reopen, we're going to reopen using all social protocols. We will have masks for employees. We believe that clients will be wearing their own masks because of the governor's mandate today that all New Yorkers will be required to wear masks in public places until further notice. We will have gloves available. We will be wearing gloves. We'll have gloves for clients, and we'll do the best we can. One of the things we're going to do is we're going to see clients one at a time in the office, so clients won't be worried about interacting with other people except the lawyers and staff at our offices, which will exercise all social protocols. I'm going to, a number of people sent in questions. I'm going to answer your questions afterwards, but for now, I'd like to get into the topic, which is protecting assets for dependent children, either spendthrift children, children who can't handle the money due to knowledge, experience, background, etc. It's almost like an epidemic. I would say that we meet people like this many, many times a week who have children who haven't had the success in life and will be unable to handle the assets that the family has acquired. And this is where trusts come in. Trusts have been termed the greatest invention in the history of the English common law, because what a trust does, it allows somebody else, the trustee, to be in charge of the money for the beneficiary, who is presumably your son or daughter. Now, historically, wills would leave assets to, the parents would leave assets to their children per stirpe, so that if their children died, it would go to their grandchildren. That's if their children died before them. However, one of the issues we see today is that children are having more trouble maturing and growing up than they did in the past. anecdotally, we see this, they say that 30 is the new 20, and we're not even sure is that good. My personal theory on this, it's just mine, so take it for what it's worth, but it seems to me as life expectancies increase, the person born today is expected to live to 100 or beyond. Because of the increases in life expectancy, it seems that the maturation process is slowed down. So we find, sons and daughters in their 30s not being as mature and responsible as some of us were, at least our clients were in their even late teens or 20s. But of course, when life expectancies were shorter, let's say, 100 years ago, life expectancy was 50, 60 years old, on average, well, you needed to be mature by 20 or you were in big trouble. So one of the things that you can do is you can delay the distribution. One popular technique is to say, I'll give them 20% at age 30, half of what's left at 35, and the rest at 40. And the theory there is they get to 20%, they blow it, but they have to wait 5 years before they get the next installment. And finally, 10 years later, when still half the estate is left, and presumably they made all the mistakes and they're mature enough, there will still be significant assets left for them. There's another way to do that. You could say 20% when I die, 30, half of what's left 5 years after I die, and the balance 10 years after I die. That's another possibility. Sometimes when we do it that second way, 20% when I die, 5% 5 years after I die, and I'm sorry, 20% when I die, half of what's left 5 years after I die, and the balance 10 years after I die. Because we don't know how old you are when you die, and we don't know how old your children are, sometimes we put a cap age. So we say, well, but when they reach 50, they get all the money regardless. Or when they reach 60, they get all the money regardless. So there's a lot to talk about there. Now, remember, assets in the trust are going to be managed by someone else, the trustee. We'll talk about who that is. But just because the assets are left in trust to the son or daughter doesn't mean they can't spend it or they can't have the use of it. Somebody else manages it. But the trustee can use the money for their health, education, maintenance, and support. So the money is available for them, but it's managed by a more mature, experienced, capable person. So let's talk a moment about who these trusts are for. Let's say you have a son, we'll call him Richard, and he has children. We could set up a trust for Richard and his children. And we call those sprinkling trusts. We also call them spray trusts because they sprinkle or spray over a group of people. So the trustee would be able to use the money not just for Richard, but for Richard or any of his children. If one goes to Harvard, can pay Harvard tuition, the other goes to a local community college, pay the tuition for that. They don't have to be equal amounts. They can be unequal depending on the needs of the beneficiaries. So it sprinkles or sprays, where it's needed. These trusts will also protect your son or daughter who may be in financial straits, may be facing a bankruptcy. Because it's in a trust managed by a third party, it's not available to creditors in lawsuits. So if you think your son or daughter may have either now or financial problems in the future, you may want to consider using an asset protection trust for them. You come into the question of who is the trustee, and this becomes, often a wrenching decision. Who do you want to put in charge for that son or daughter? Now, initially, you might think, well, why not pick one of their siblings, brother or sister? But the problem with that is that as soon as the brother or sister says no to something, it creates a rift, and they may end up not talking to each other. So one of the ways to get around that, because the brother and sister knows the their sibling, you could say, well, I pick my lawyer and so-and-so's brother or sister to act as co-trustees. And this way, when there's a request that may not be reasonable, the lawyer can say no instead of the brother or sister, and it saves the family relationship. So the lawyer plays the bad guy. We generally do like two trustees wherever possible, because two trustees acting together avoid some of the problems of carelessness, negligence, lack of knowledge, and possibility even of dishonesty. If they both have to sign, you're protected from a lot of those issues. What about naming friends, relatives, nieces or nephews? A lot of people will bring up this issue, and the concern there is that these people are reluctant to say no. So they say yes, but they don't know what they're saying yes to. It's an enormous responsibility to be a trustee. There's fiduciary obligations. You have to act in the beneficiary's best interest. You're responsible for tax returns. You're responsible for the investment of the money. You're responsible for losses. You have to invest according to the prudent investor rule, which is how a prudent investor would handle their own money. And there's a certain standard. Fortunately, in New York, we have something called the unitrust election, which is you invest the money in a state-sponsored fund sponsored by the state of New York. They have a guaranteed, some guarantees in there. The money's protected. They manage it according to trust rules. You're deemed to have met the standard of the prudent investor rule if you use the unitrust election. So you elect to invest it according to the terms provided by the state of New York and the investments that they provide that are adequate for that purpose. Professional advisors, you may have a very good relationship with your financial advisor, but they have a conflict. They can't act because they can't be the financial advisor and the trustee at the same time because they're not independent. They can't exercise independent judgment. For example, they can't decide to go to another financial advisor because they are the financial advisor. So we want more independence. Accountants, perhaps, you know, they do know the family, et cetera, but you have to also consider somebody who's going to distribute and handle the plan the way you would want. Do you want them to be very conservative? Do you want them to be liberal, et cetera? These things have to be fleshed out. So obviously, when you're talking about dependent children, and again, you know, it's a broad range, you're talking about who should be the trustee, the terms of the trust. It requires obviously a discussion with the client about the various people who they think might be good, whether they want a co-trustee, et cetera. But trusts are the solution to this problem. They have been for a long time. Other people have special needs children. And special needs children are those who are receiving government benefits, usually Social Security income. Medicaid is attached to that. And special needs trusts have been around since 1993. Back in 93, the government determined as a matter of public policy that we as a state want to be able to provide for our special needs children. What had been happening prior to 93 is that a lot of special needs children were being disinherited because the parents realized that if they left money to the special needs child, they would lose their government benefits, Social Security, and Medicaid. So the state, as a matter of public policy, decided we were hurting our special needs population, but we weren't helping them. So in order to help them, they said, why not allow parents to set up a trust to pay over and above what the government will pay for our special needs population? So these have been the law since 1993. They're not that difficult to set up. The provisions and the rules are pretty well understood. So what are some of the items that might be over and above what the government would pay for a special needs child? You know, including your section special housing, uh, Section 8 housing, et cetera. Well, there could be clothing that the state wouldn't pay for. There could be essential dietary needs that the state would not pay for. The state won't pay for education, hobbies, sports, and exercise. On the list, we have tickets for events, healthcare costs, and elective medical procedures, maybe cosmetic procedures, vocational rehabilitation, learning to do a new job. The state doesn't pay for appliances or furniture or a computer or television. These could all be paid by the Special Needs Trust. A couple other things: personal care products, personal services, lawn mowing, house cleaning, babysitting, music, real estate. The Special Needs Trust can own a condo, can own a home. The state will not pay for a car. The Special Needs Trust can pay for the car and own the car, as well as pay for the gas and insurance, as well as transportation, vacations, and burial costs. The Special Needs Trust has some traps for the unwary. You cannot pay the money directly to the special needs child because Social Security payments are reduced dollar for dollar on any payments made directly to the child. So payments need to be made on their behalf to providers of goods and services. It's crucial to preserve SSI eligibility, because if you lose the SSI, you also lose the Medicaid. The Medicaid is tied to the SSI, and that's, of course, the health insurance program. Sometimes you can lose eligibility because the grandparents, well-meaning, have left a gift to the special needs child because they're very concerned about that particular grandchild, and they mean well, but it can do damage. So we have to be careful of well-meaning grandparents. What if a sister or brother dies without a will? If a sister or brother dies without a will, a portion of their estate will go to their sibling. So we have to be careful about that. So as I say, the trust can own furniture, but any distribution should be on behalf of the beneficiary, the special needs child, or to a person taking care of them. The special needs child cannot have any direct access to the funds. There's also two types of special needs trusts. There's the first party trust and the third party trust. The first party trust is set up either by the special needs child themselves, because they have legal capacity, they can do that, they can meet with a lawyer and sign for themselves, or it could be set up by a parent, a grandparent, a court-appointed legal guardian, or the court itself. So first-party trust is the child's own money. They may have earned it, they may have received an inheritance, they may have a personal injury award. The thing about first-party trusts, the key distinction between a first-party trust, which is set up by the special needs child for themselves or by a parent on their behalf, the first-party trust is with first-party money. The third-party trust is with money from a third party, like a parent or grandparent leaving money to a special needs child. We'll get to that. But the first-party trust has something called a payback provision. Now, payback provision means simply this: the state will allow special needs children to take their own money or money that's coming to them, put into trust for their needs over and above what the government would pay. But that trust says when they die, the assets that they didn't use will go back to pay the state for any benefits distributed. The theory here is that we allowed the special needs child to protect their money in case they needed it. But after they passed, it was clear whatever's left they didn't need, so that should go to pay back what benefits they received. That's the thinking there. They require annual accounting to the state. The state wants to see about how those funds are being used, and it's limited to children under age 65. The third-party trust, which I would say is used much more often, is set up by a parent or grandparent, and it's using their own money. There's no payback provision because the state is aware that if there was a payback provision, a lot of parents and grandparents simply would not leave the money to the special needs child, and they don't want that. They want the special needs children to be helped. So what happens to the money when the special needs child dies? Well, that's going to be up to our parent or grandparent. They could say it goes to their brothers and sisters. If they have children, they could say it goes to their children first and to their brothers and sisters second. If they don't have brothers and sisters, it can go to nieces and nephews, it can go to a charity. It's going to be up to the parent or grandparent who set up the special needs trust to provide who they want it to go to, if there's any balance left when the special needs trust child dies. So again, the money can be used for their health, education, maintenance, and support. These trusts are much more significant today because due to advances in medical science, our special needs citizens are living much longer than they used to. So very often, historically, very often special needs child died before the parents. These days, most special needs child will survive their parents. And what happens is, there's that old expression, the tongue always turns to the aching tooth. Similarly, parents will often bend over backwards to provide for the special needs child because they feel that's the one, obviously, who needs more than the others. But this can create resentment in the other children, and they might need the funds later on. Vicissitudes of life. We don't have to talk about that today. Everybody knows things can happen unanticipated. And I should have mentioned at the beginning of the call, I hope everybody is safe and well, and I wish everybody the best during this time. But things change. A child may initially say, well, sure, you could help Johnny more because he needs it more. But later on, when the parent dies, it turns out they really need the money and they're very resentful. So one of the issues is how to make it fair for all the siblings. I should mention, the surviving siblings are also the only, often the only means of support, emotional and psychological and social support. So you don't want to have them be resentful or alienated. You want to keep peace and harmony in the family. So one of the things is to consider whether first, would an equal share of the assets be enough for the special needs child? If an equal share is enough, then it's fine. You're not going to have that problem. Very often we find the special needs child needs less than an equal share because their needs and expenses are much less. And of course, a lot is paid by the state. But sometimes they do need more. And that's because they're going to need support for the rest of their lifetime. And one of the techniques developed for this purpose is something called second to die life insurance, second to die. And it means what it says. If there's two parents, they take out a life insurance policy over the both of them. And the policy pays when the second parent dies, which is when the special needs trust comes into effect. It gets funded when the second parent dies. Well, that's the time when we need the assets. So this insurance is actually quite a bit less expensive because it insures over 2 lives. The insurance policy doesn't have to pay until both parents are deceased. So being as 2 lives, there's less of a risk. It takes a longer time, so the premiums are lower. So this is something we need to consider. The other thing is, with a special needs child, it's recommended that the client, parents, write something called a letter of intent. I would urge you to Google this term on the internet, letter of intent. And what a letter of intent is, it's a kind of an advice from the parents to the trustee as to the likes and dislikes of the special needs child. Their hot buttons, what you need to know about them, how do you manage them, what difficulties, what are some of the solutions. It's a very broad topic, but it also includes their daily medical needs, their routines, as I say, their likes and dislikes. Again, Google letter of intent and be sure to write one if you have a special needs child. There were a few questions. Again, I want to reiterate, you can contact me at mettinger@trustlaw.com, METTINGER@trustlaw.com if you have a question that wasn't answered. But we did get a few questions in, so I would like to answer those. They were sent ahead of time, so if you have a question for next week's webinar, you can send in your questions ahead of time, and we'll try to answer them on the Zoom chat. Bill Burdick wrote, under what circumstances and timing should the beneficiary of a special needs trust be informed of the special needs trust? Well, that's a great question. And it's a good question just in general about when should we tell our heirs about our estate plan? There's no right answer to this one. One issue is, if you disclose what your plan is, it makes it hard for you to change your mind. Then you have to go to somebody to tell them, well, you changed your mind. So you may want to keep it close to the vest for a time. Keep your cards close so you can change your mind later on without having to go back to the person and saying what you said wasn't what's going to be. But I meet a lot of families who say that everybody discusses everything. They're very open and they want to discuss, and I say, fine. Well, if that's your dynamic, then by all means. So keep in mind that there's nothing wrong with discussing it, but you have to consider ahead of time the social impact. Will the person be perhaps upset about it? Will they be resentful? Will they start asking a lot of questions that you may not want to answer? It's a very tricky proposition. So again, it's done on a case-by-case basis, and it's a good thing to have maybe a 15 or 20-minute talk with an estate planning lawyer about and flesh out all the issues as to the comprehension level of the special needs person, whether they'll be resentful of the special needs trust, whether they will object to your choice of trustee, a lot of issues. And there's a whole continuum of people on the line of special needs, a very, very broad range. So it has to have a discussion. But generally, it's not just special needs, it's people, do they want to discuss their estate plan with their children? Do they want to tell their children that, well, I'm setting it up so that there's a trust for you, and if you die, it's going to go to your children instead of your spouse? Will they object to that? Will they want to see a copy of the trust, bring it to their lawyer, and have the lawyer review it, and then have their lawyer involved in your affairs? So these are very tricky things. And generally, I would prefer that it not be discussed ahead of time unless it has to, because again, it forecloses some of your options later on. Janet Lyons-McGrory asked me a complex question, which I cannot answer on the internet. So Janet, if you email me, I will answer you by email. Here's a question about a tax-deferred annuity. A tax-deferred annuity is a qualified plan is deferred to 72. So this answer would also include IRAs, would be the same, 401ks, 403bs, all retirement plans deferred under the Secure Act now to extend it to 72. The question is, if somebody dies owing money to a nursing home, can the nursing home go after the retirement money, the TDA or IRA or 403b? And the answer is no. Nursing homes and Medicaid have no claim except against a will. They can't claim against the beneficiary designation. They can't claim against the trust. So the right of recovery for Medicaid is against the probate estate. Because what happens is when the will gets filed, notice goes to Medicaid that here's the will is filed, and if they have a claim and they cross-reference it. So Medicaid is tied into the probate court system. They'll know when somebody dies and they had an estate. But that's all they're tied into. So they have a claim, they can file their claim against the probate if you have a will, But if you have a trust, there's no filing, there's no probate, so there's no claim. So one of the reasons we use trusts is to avoid the right of recovery from Medicaid. It's kind of a loophole, but a very important one to know. Here's a person who owns a home that is in her name. It's a blended family, but her husband lives there, obviously her second husband. And if she passes, she wants her husband, this is Francine Kudlak, she wants her husband to have the right to stay in the home and then to go to her children. And the classic here is a trust. And most of these trusts read, my spouse has the right to stay there, life rights, but if he leaves the house will be sold and the proceeds distributed to my children. This is the way most lawyers do it, but we have come up with what we think is a better plan. Because what we have found with the traditional plan is that it puts the husband, could be a wife in this, but in this case, the husband, it puts the husband in catch-22. Well, I have the right to stay in this house, and I'll usually say, provided you pay taxes, insurance, upkeep, and maintain the premises in good order and repair. I have the right to stay in this house, but if I decide it's too much or I can't maintain it, if I move out, I have nothing. I have no place to live. It puts you between a rock and a hard place. So what we prefer to say is keep the house in trust for the spouse, but give him the right to sell the house and buy a condo. Sell the house, buy a smaller house. What if the house is worth $800 and the condo is $500? Well, the rest of the money gets invested, the $300,000 difference, and he gets the income, the interest earned on that money. And then the condo and the money will go to the children after he passes. So we say that husband has a right to live in the house or any property substituted for the house. I'm sorry if you raised your hand. I will be unable to answer your question, but I will look at being able to do that next week. So in the meantime, if you raised your hand, you have a question, email me, m@ettinger@trustlaw.com. We'll be happy to answer it. And next week, we'll look at and see if we have to beta test it. We have to test and see if we can actually answer questions without losing our train of thought. Certainly at the end, I can answer questions. And if you'll allow me, Joan, I know you raised your hand a number of times. If you want to answer, type in your question, I'll see if I can answer that. Here's a person, I don't want to mention her name, it's a personal issue, but she wants to know how she would help her sister who suffers from schizophrenia, and she's not totally disabled. She's been on work disability for many years, but she wants to make sure her bills are paid, etc. Should you have power of attorney? Absolutely. You should have power of attorney and health proxy living will. A power of attorney allows you to handle your sister's legal and financial affairs. Health proxy living will allows you to make medical decisions, including end of life, pull the plug, so to speak. So yes, power of attorney, health proxy living will, some of the most important legal documents that someone can have. So that covers my remarks for this week. Next week, we're going to talk about estate planning for grandparents. There are some issues there. How do you protect the inheritance you leave from children's divorces, lawsuits, and creditors? How do you keep assets in the bloodline so it goes to your grandchildren instead of your son-in-law or daughter-in-law if your son or daughter dies before their spouse? We don't want it to go to necessarily the son-in-law or daughter-in-law who get remarried and share the inheritance you left with a complete stranger. So we're going to talk about inheritance trusts to protect the assets from divorces, lawsuits, and creditors. And we're going to talk about keeping assets in the bloodline. The other thing we're going to talk about in estate planning for grandparents is what plan should your son or daughter have? And I'm talking about those of you who have sons and daughters who have children, so you're the grandparents. And if they have young children, we'll say minors under age 18, there are tremendous pitfalls in not having a will, a power of attorney, health proxy, living will. So I'm going to tell you what your sons and daughters need if you're a grandparent, as well as what you need, and what actually happens when people die without a will. And that should be enough to get people going. On our website, it's easy enough to find the written articles on inheritance trusts to keep it in blood. And we have an article entitled Young Family Estate Planning, which you'll be able to send to your sons and daughters so that they make sure that they're planned properly. And the other issue is life insurance, which again, I'll talk about a little bit next week. But if we go back to 9/11, in 9/11, there were quite a few 30-somethings that were working at Cantor Fitzgerald, the large financial firm, who died in the Twin Towers disaster. We found that most of those 30-somethings did not have enough life insurance to take care of their young families. Fortunately, under the Terrorism Act, the federal government bailed out these families and paid, over $1 million per family on average to take care of the loss. But if you have a son or daughter in their 30s, let's say example, and they die, nobody's going to bail them out if they don't have life insurance. And I talk to my clients about this because I tell them, look, if your son or daughter doesn't have enough life insurance to take care of their children, then you're the life insurance. It's going to be, you're not going to let your grandchildren go hungry or go without or not be able to afford college or whatnot. So you're going to be the second line of defense. So it's going to affect you significantly if they don't have a plan. So make sure that your sons and daughters have adequate life insurance to cover their responsibilities. So again, it doesn't become your responsibility. More about that next week, but I hope this was helpful. I thank you for listening, and I'll practice this week taking questions online and see if we can do that. And I want to thank you for tuning in, and again, stay safe. Thank you very much, and we'll leave it at that for now. See you next week.